We're back. Now that you've read those articles about the contract, I want to go through 6 important contract clauses to make sure you understand them. And these are areas that are going to give you the power every day to challenge what your employer does and how it affects your members. Each of these articles is also a way to help you in an open shop sign up the non-members. And I stress that everything the union does in terms of filing grievances needs to be directed at signing up non-members, because unless your local is 100%, you're not where you need to be. So the 6 articles are the Recognition Clause, the Non-Discrimination Clause, union activities on company premises and protection for your union activity, the Just Cause provision, which is involved in discipline and discharge, the health and safety language, which is very, very important, and then finally, the elements of the grievance procedure itself. The Recognition Clause is usually the first article in the contract, and it is the single most important article that you have. And it generally reads that the employer recognizes the union as the sole and exclusive bargaining agent for the purpose of collective bargaining in respect to wages, hours of employment, and all other terms and conditions of employment. And this expression, all other terms and conditions of employment, is absolutely essential, because that means anything in, around, or related to the workplace can be bargained and grieved. So anything that the company does, anything that they tell you you can't do off the job, what you can wear, you can't wear, is now open to a grievance procedure. It's very important because this is your answer to the company's management rights clause. Because often you'll come into a grievance and the company will say, oh, you can't grieve that, it's a management right. Well, the Recognition Clause is our response to that. And I want you to read this article, the Recognition Clause, as a weapon, because I lay out in there exactly what we're talking about here. This clause gives us a power, as I said, to take away the management rights clause, which the employers use, both private sector and public sector, to increase their control. That is, more and more, if you look at your contract, management rights clauses get longer and longer and more inclusive. And that's the line of scrimmage. That's where our employers are trying to gain more control over the workplace. And it's part of this overall drive that we talked about earlier to turn the United States into a non-union country. Because in a non-union workplace, the employer has total control. And the union challenges that. And the management rights clause is one way in which we do that. And if you remember from the history lesson that when the auto workers first sat down at Flint, Michigan and got their initial contract, there was nothing in it but a recognition clause. And they felt that was enough because that gave them the legal and social and political and organizational right to challenge everything that the management did. The non-discrimination clause is very important, and it's important to you as a steward depending on how the language is. You're familiar with it, and it can be very complicated about discrimination against any employee on the basis of race, age, religion, disability, sex, sexual orientation, marital status, and there are all kinds of new ones that are added all the time. But your contract should have a provision that you cannot be discriminated against because of your activities in behalf of the union. And what we're going to see is that often stewards are targeted for their activities. And it's a way of the management trying to get at the union by picking out the most active and visible members of it and putting them out of the workplace. And we've got to stop that if we're going to build our union and defend it. We will also look later on in this section at laws that protect your activity in support of the union. If you're in the private sector in the United States, the National Labor Relations Act very clearly says that an employer may not discriminate against an employee because of union activities. Some state collective bargaining laws or public employee legislation has that protection. Not all, but that's why it's very important the next time you go into negotiations, you need to get this language in your contract about protection for union activities. Because this is one of the areas which is a very controversial one for you as a steward. What can you do on company premises? And what are company premises? This becomes a greater area of controversy as new technology develops. For example, can you use the company email system for union business? Can you discuss a grievance with a member on an email system run by the company? I advise against it just as a good union practice, but you may find that your employer will try and discipline you. And what they are doing is trying to attack the union. So what you need to know as a steward is what is defined as the workplace. What can you legally do on company premises but not in the workplace? That is the workplace the break room? Is it the parking lot? Is it areas outside the garage, for example? Is a bus, if you're sitting there at rest, considered a workplace and you cannot talk about union activities there? These are all issues that you have to deal with. Because what will often happen is the management will not want to deal with the merits of a grievance, for example, an overtime pay or a health and safety issue. And so what they will then do is come after you as a union steward. And they won't come after you for filing a grievance on health and safety. They'll come after you for using company premises in a way that's not authorized. And so you need to make sure that you understand this. What I have found in my experience is what's defined as a workplace depends on the hours of work. I had a situation where a woman was leafleting in a mechanic shop before the shift started. And the company fired her for using the workplace for union activities. And the National Labor Relations Board changed that because they said until the work shift actually starts, it is not legally defined as a workplace. So this was a great change, and these are things that you need to look at. Look at your contract. What does it say? What stewards have done in your shop as past practice? That is, what have they done? We're going to be talking about the importance of past practice here in just a minute. But have stewards been able to talk to coworkers in the garage, for example, about a workplace situation that could be a grievance? And has anything been done? What activity can a steward carry on company time? Who pays for it? And we're going to be talking about this as well. And as I said, when is a work area a, quote, work area, unquote? Because we're operating in many cases on a 7/24 situation, but a lot of smaller locals have very clearly defined hours of work. And so people will be in the garage 15 minutes, 20 minutes before the shift actually starts, often before they're actually punched in. And so the question is whether this is a work area or not, whether the employer can stop you from doing union business in that area is an issue that we want to talk about. So this is the questions about, again, on company premises. Can you investigate a grievance? Can you meet with a potential grievant or grievance? That is, can you sit down and have a coffee in the work area and talk about who got paid overtime, who got denied a job, who may have been disciplined unfairly? Can you hold a workplace meeting? That is, can you announce, for example, what happened in negotiations or how a grievance is going, or to encourage people to use a group grievance? Can you use the company systems, the email, the phone, or the electronic for union business? Can you solicit or distribute union material in the company premises? And let me just define the word solicit and distribute. And solicit means that you pass out something, but you ask for something back. One of the most common events in this area is signing up new members. If you don't have a set time to meet with the new members before they actually start work, as they're on the job, you want them to join the union. And so you may pass out to them a checkoff card, a membership card, and you want it to be handed back. That's called solicitation. Distribution of union materials is simply one way. That is, you have a leaflet, you have a bulletin of some sort, and you pass it out. But can you do these on company premises? Can you do them on work, or non-work hours, work areas, non-work areas? And the reason I raise this as part of your contract is that you as a steward have to be able to contact your members in the most convenient way. And you don't want to be disciplined for it, because if you are and get fired, for example, nobody's going to want to be a steward. And we've had locals where that happens and the companies try to do it. Here are a couple of examples of contracts from the ATU which are different. The one in the ATU Local 1764 and MV Transportation says you cannot conduct union business while on duty. That is, if you're punched in, you cannot talk to anybody about the union. This is a very restrictive clause. It may be conducted during the employee's authorized break or lunch period and not in a work area. This includes employees coming to a steward's desk or vice versa to discuss union matters, except in emergency situations. And we're going to be talking about that phrase, emergency situations, a little bit later. But in contrast, you see a local in New York City has a much broader release time. And this will even pay for employees to conduct union business. And so when you come up into negotiations, you need to look at expanding this clause to protect yourself as a union steward. Because these are protections for you. And one of the stewards that I had in a training class here said, we need to protect everybody's precious ass on the job, but the most important precious ass I need to protect is my own. And if the union can't protect the stewards, other members are going to get scared and the union is going to go downhill. So these are the very, very important areas. And as a steward, you have to be aware that you are constantly under surveillance by your supervisors and by management, because they're going to look for a way to try and get rid of you. This is a story that came out recently. It was revived from 20 years ago, but it was a strike 40 years ago, in which the head of the Washington Post, Katharine Graham, hired a new labor relations chief. And he said in the memo that the purpose of corrective discipline was to demean the employee in the eyes of his family, in the eyes of his fellow employers. We do not demean an employee if we simply take away an economic benefit or a privilege. If a union official abuses his leadership responsibilities, accelerate his punishment. Give a written reprimand to the other words and give him a suspension or give him a longer suspension than others. And I'm not saying this to frighten you, but I'm simply saying this, as a steward, as an officer, you need to protect yourself. And you need to rally your coworkers around so that every one of them is a steward. I want you to read the document, Je suis my steward. And this is based on the activities of people in France a couple of years ago after the terrorist bombing. They all said that they were victims, and they stood up in solidarity. All right, we're going to take a break here. I want you to go back and look at your union contract for some of the clauses that we've been talking about, and we'll be right back.